My Lord E. Otrofanowe, my learned friends C. A. Oputa and A. O. Ishokare appear with me for the defendant.
My Lord. Sorry, are we still connected to the court?
I'm not hearing anything.
I can't see my Lord.
I can't see him too. But he's there as a participant.
He muted his video. He turned his video off and then muted his mic. He's still on.
He's still on?
Yes.
We are not hearing anything. Are you in the courtroom?
No, his video is, I just checked the details. His video is on, is off, and he muted his microphone.
Okay, I'm seeing NICN muted. Video off. How do we wait for them, or I hope proceedings are not going on in the court while we
No, he's going to turn on the video. Probably he muted it and then turned off the video. He will turn it on again.
Okay. Good morning. Good afternoon, sir.
So sorry for the inconvenience. My Lord is gone. Hello, Council. Good afternoon, Council. My Lord is connecting back.
Okay.
Thank you
So
very much.
let's just be patient. So sorry for the inconvenience.
Thank you very much.
Thank you, sir.
Yes. Yes. Okay, much the taco. Mano, namad.
Yes, can you hear me now?
Yes.
Okay, go ahead. Mr. Tropanoe.
Yes, my lord.
Yes, go ahead, please.
Oh, my lord, E. Otrofanoe, my learned friends, C.A. Oputa, and A.O. Ishokare. Ishokare is I-S-H-O-K-A-R-E. They appear with me for the defendant.
C.A. Oputa and who?
A.O. Ishokare.
A.O. Ishokare.
Ishokare is I-S-H-O-K-A-R-E.
Okay. For the defendant.
Yes, my lord.
So I'll go ahead now and read the ruling. This is a ruling in respect of the application initiated by the defendant applicant filed on the 18th day of February 2022. Application brought to person to Order 17, Rule 1, 2, 3, and 5, and Order 10, Rule 5, 10, and Order 47, Rule 26 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, and under the inherent jurisdiction of this court, whereas the defendant applicant prayed the court for the following relief. An order setting aside the subpoena duces tecum dated 15th day of July 2019 purportedly serve on the office of the acting managing director of the defendant. The defendant applicant further stated the ground upon which the application is brought as follows. A, that the documents demanded are not relevant to the issue in contest in this case, as no issue turns around the sums received as derivation funds for the said period requested. Secondly, pleadings in this case has long been settled with claimant listing out their witnesses, and no notice of a witness being called on subpoena was given in the pleadings. Thirdly, this honorable court on the pleadings was misled to issue this subpoena, which is incompetent and liable to be struck out. And B, the claimant having given notice to produce the said documents is only entitled to tender secondary copies thereof, and parties are not allowed to spring surprises on an opponent during trial, and that the said subpoena is merely a fishing exercise and calculated to harass, embarrass the defendant or spy into its affairs outside those in dispute in this case, and that the Delta State government, who is the owner of the said document and employer of all staff in the defendant and who is not a party to the suit, does not authorize the release of the said document. And lastly, there is no position as acting managing director of the defendant. The application is supported by a 12-paragraph affidavit deposed to Bawan Dixon at Jebu, a member, and a written address. The defendant applicant further filed what is called reply to counter affidavit deposed to by Dixon at Jobo, a member, on the 2nd day of March 2022, in a reply to the claimant's address. The claimant respondent often been served with the defendant applicant's application file a 12-paragraph counter affidavit deposed to by one Hua Aibo and a written address in opposition to the defendant's application. The defendant applicant deposed in his affidavit stated that he has perused the said subpoena and see that the said document relates to allocation of funds by the state government to the commission, that the said allocation of funds to the commission is not a dispute in this suit, and that the documents required to be produced in court have no nexus with the issue in dispute in this case, that the claimant gave notice to produce same only in his pleading and gave no notice of calling any witness on subpoena, that it is necessary to bring this application into this court so as to set aside the order, as the subpoena issued is brought simply to harass the defendant and his staff and bring materials not relevant to the issue in controversy into this honorable court. That the deponent further stated that he was informed by the head of legal department of the defendant that the documents sought to be produced are documents belonging to the Delta State government, employers or staff of the defendant, and they do not consent to anyone producing the said documents, and there is no acting managing director of the defendant. The defendant applicants further stated that the fund received by the applicant is not an issue in this case, as respondent never denied the fact that the funds are dwindling, that the documents sought to be tendered are documents of the state government, as a defendant is a fully owned commission of the state, that an acting managing director is not an alter ego of the defendant, as it is not a position known to law setting it up. Paragraph 9 of the counter affidavit is true only to the extent that the subpoena listed some documents. However, the said documents have since been tendered by claimant's first witness and admitted as an exhibit in this case. The application is one within the right of the applicant to bring and not calculated to cause any delay. Rather, it is the respondent that is delaying the trial by bringing up issues outside those in contest in the suit. The claimant respondent stated in his counter affidavit that the applicant made funds of the defendant as an issue in its defense to the claim of the claimant at paragraph 5D, E, F, and G of the statement of defense. And the claimant respondent pleaded the facts in paragraph 7 of its reply to statement of defense. The source of funds to the commission is 50% of the 30% derivation to the government of Delta State. And the documents are relevant to the just determination of this case, and it is in the interest of justice that all relevant documents are not withheld to this honorable court, that the fact of the evidence has been pleaded and a subpoena witness is competent to tender the relevant documents in its custody. That the documents are to be tendered to this court is only the record of 50% of funds received by the defendant from Delta State government and not the 13% derivation to the Delta State government. That the subpoena was issued by this honorable court on the 13th day of July 2019, when the defendant had only acting managing director in person of Mr. Leos Aji, after the dissolution of the board of the defendant on the 28th day of May 2019, and held sway till on the 31st day of August 2019, when Chief Bashir Askia Oge was appointed as the managing director of the defendant and took over from Mr. Leos Aji. The subpoena is directed to the alter ego of the defendant, and any of its officers is competent to tender the documents in court by the nature of the directive in the subpoena. That apart from document number 39, which is sought to be brought to this honorable court, there are other 38 documents that the subpoena witness is commanded to bring to this honorable court. The defendant applicant nominated 2 issues for determination of this application, to wit, firstly, whether this honorable court in the circumstance was right in issuing the subpoena disestakum, and secondly, whether the said subpoena in the circumstance is not liable to be set aside. The claimant respondent adopted the issues nominated by the defendant applicant. I suppose the issues that calls for determination of this application is whether the defendant applicant's application is competent, given the affidavit in support of the application. I've carefully gone through the affidavit, the defendant applicant's application. It is pivotal to prove the validity of the affidavit in support of the defendant applicant's application. A clinical reading of the defendant applicant's affidavit in support of the application reveals that Dixon Ajobu, IM by the deponent, who is a solicitor in the law firm of the defendant applicant's counsel, does not state that he has a personal knowledge of the facts deposed to in the application. Neither did the deponent disclose the source of his information deposed to in the affidavit in support of the application. Though paragraph 9 of the affidavit in support of the application stated the source of the fact contained in paragraph 9, but not in compliance with the provision of section 115(4) of the Evidence Act. There is no information as to when and how he received the information and the circumstance that led to the fact stated in paragraph 9. In the case of Cedar Stationaries Limited against IBW Limited, reported in 2015 NWLR Part 690, 338 at page 370, where the court held, and I quote, "It is incumbent on the person who deposes to his belief in a matter of fact that those belief is based on any source or sources other than his own personal knowledge, unequivocally must disclose the facts and circumstances forming the basis of his belief. Furthermore, when the belief is founded upon an information received from another person, the name of his informant must be stated in the affidavit and must state reasonable particulars of such an informant, including the time, place, and the circumstances of the information. In the instant case, the deponent woefully faulted in stating the particulars of the various informants from whom he derived his information, no place, no time, and no the circumstances of the information. The paragraph deposed to by staff of Mr. Offion without due heed to the provisions of Section 88 and 89 of the Evidence Act deserves to be struck out and are accordingly struck out by me, unquote. See also the cases of Bank de Afrique against Alhaji Baba Shapadi and others, and the case of Idris Wilfred Horn against Robert Ricard. In the same vein, the reply to counter affidavit suffered the same congenital deficiency. It may be argued that by paragraph 3 of the affidavit in support of the application, the deponent disclosed the source of his information. He disclosed the source of the information as to the service of subpoena disos tecum. In fact, the deponent used the first personal person pronoun, I, to state the facts. This makes one wonders how the deponent became seized of the facts in paragraph 4, 5, and 6. And by virtue of Section 115 sub 1, that a deponent who has no personal knowledge of the facts deposed in an affidavit must disclose the source of his information. In effect, where the facts deposed in an affidavit by a person is derived from another person, the name of his informant must be stated and reasonable particulars given in respect of his information, such as time, place, and circumstances of the information. In the case of Jimo against Minister of FCT, reported in 2019, 5 NWLR Part 1664 at page 63 to 64 paragraphs H to A, the Supreme Court held, and I quote, a deponent of an affidavit in any proceeding before a court of law is a witness in the matter. Section 115 sub 1 of the Evidence Act 2011 enjoins a deponent as a witness to depose to facts in an affidavit that either of his own personal knowledge or from information which he believes to be true. It is not enough to set out in the preamble paragraphs of an affidavit for the deponent to restate the facts that he has been authorized either by his principal or employer or client to make the affidavit, and that he derived the facts averred in the affidavit in the course of his employment and or from his personal knowledge and or information generally. For every assertion in a specific averment, the deponent must be consistent with Section 115 sub 1 of the Evidence Act. He must disclose with particulars the source of his information and belief, unquote. More so, in the case of ACN against Enyako, the Supreme Court held, and I quote, in the matter of the taking of evidence, be they oral or written, or as in the case in hand, '86, '88, and '89. This is in keeping with the legal principle on the face of it. Hearsay evidence is inadmissible, and so to be taken seriously, such evidence needs its source to be put on display, including the name of the informant and the circumstances, unquote. The resultant effect of the defective affidavit in support of the application is that a deponent to an affidavit who does not have the personal knowledge of facts deposed to an affidavit and does not disclose his source of information has not told anything to the court, and the abatements go to no issue. See the case of Edu against Commissioner for Agriculture. It is necessary for a motion or notice to be supported by an affidavit, and where the supporting affidavit is defective, the motion is vitiated and liable to be struck out. See the case of SCN against Escort, reported in 2020, 11 NWLR Part 1734, page 177, paragraphs B to C. Flowing from the foregoing, the defendant applicant's application is incompetent given the defective affidavit in support of the application and it is hereby struck out. Assuming I am wrong, for the faulting of the defendant applicant's affidavit in support of the application, may I further consider the said application on its merit. The basis of the application is the order for subpoena made by this court requesting the acting managing director of the defendant to produce a document relating to the allocation of funds by the Delta State government. The defendant applicant stated that allocation of funds to the defendant applicant by the state government is not an issue. Further stated that the Delta State government did not consent to anyone proceeding the said document, and there is no acting managing director of the defendant. The claimant respondent stated otherwise, that the applicant made funds of the defendant an issue in its defense to the claim of the claimant at paragraph 5D, E, F, and G of its statement of defense. The claimant respondent pleaded the facts in paragraph 7 of its reply to statement of defense. The source of funds to the commission is 50% of the 30% derivation to the government of Delta State. The documents are relevant to the just determination of this case, and it is the interest of justice that all relevant documents are not withheld to the honorable court, that there are other documents that the subpoena witness is commanded to produce before this honorable court. The defendant applicant, on the other hand, argued that the case of the claimant is pleaded in paragraph 4 to 20 of the statement of facts and paragraph 1 to 21 of the reply to the statement of defense, submitted that on the face of the joint issues of the dispute in this case centers on the condition of service of the defendant and whether same was breached. No issue outside the breach of conditions of service was raised, whether on the pleadings or in the witness deposition file in this honorable court. Submitted further that for there to be said to be an issue answered from the prayers, there must be facts pleaded and a denial or contest of same. Counsel for the defendant applicant further argued that paragraph 7 of the said reply to the statement of defense is not in response to any paragraph or issue raised in the statement of defense. No issue turns around the sum received as derivation form, and cited the case of Okojo Meno against Bakeji and another. The defendant applicant further argued that a person served with subpoena has the right to apply to court to set same aside on the ground that the subpoena is not bona fide required for the purpose of obtaining evidence that can be or is relevant to the case. That the court on application will interfere where it is satisfied that its purposes are being used for improper object, and cited the case Obi against Odu against Duke. The defendant applicant further submitted that the claimant responding its reply to statement of defense gave a notice to produce. That notice to produce by its nature is totally different from subpoena duces tecum. That while a party served with a notice to produce fails to produce same, the only avenue open to the party who has issued same is to tender secondary evidence in his possession. The claimant respondent argued that the parties clearly have joined issues on the evidence sought to be brought to this honorable court in their pleadings in this suit. Firstly, the defendant at paragraph 5, D, E, F, and G of its statement of defense raised issue of dwindling funds of the defendant and how that has affected the capacity of the defendant to attend to the condition of service of the claimant's members. The fund of the defendant is the 50% of 13% derivation from the revenue of the government of the Federation as remitted to the Delta State government on a monthly basis. The claimant respondent pleaded the facts and joined issues on the facts in paragraph 7 of its reply to statement of defense. The documents are relevant to the just determination of this case, and it's in the interest of justice that all relevant documents are not withheld to this honorable court. And counsel asked this court to discountenance the submission of the defendant applicant in this regard. The defendant applicant has argued in paragraph 3.07 of its written address that the claimant respondent did not give notice of calling witness by subpoena duces tecum and relied heavily on Order 3, Rule 9 and 15 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017. This argument is misconceived and oblivious of the nature of subpoena in proceedings before this honorable court. The issuance of subpoena is regulated by Order 38, Rule 18 of the rules of this court. Submitted, therefore, that the subpoena was properly issued in accordance with the rules of this honorable court and case law empowering this court to do so. The defendant applicant also argued that paragraph 3.8 of its written address that the claimant respondent only gave notice to produce the documents and should not be allowed the benefit of subpoenas, and submitted that the notice to produce does not preclude a party from applying for a subpoena in the course of proceedings, where such document becomes relevant in the trial proceeding. The subpoena directed the production of certified true copies of public document listed in the subpoena. But the secondary evidence allowed for the public document, the certified true copy, which is the circumstances in this case, can only be issued by the defendant applicant who has custody of the said document. Thus, the only available route for the production of the document in the manner allowed before this honorable court is by production and certified copies. The defendant applicant is fixated on item 39 on the subpoena and choose to ignore the other 38 documents in the said list. And the claimant respondent has, in addition to the list of documents, attached photocopies for ease of certification. Further submitted that notice to produce and issuance of subpoena are different, as held in the case of Akande against Rabiu Adejare Bello and others. Having just opposed the submission of counsel from both sides, vis-a-vis the pleadings before this honorable court, I have no difficulty to say that the defendant applicant raised the issue of allocation of the defendant applicant from the Delta State government in its statement of defense, specifically paragraph 5 of the said statement of defense, made the claimant respondent join issues with the defendant applicant through its reply to statement of defense. The dispute on the issue of allocation of the defendant applicant prompted the claimant respondent to apply for the issuance of subpoena. The claimant respondent does not have the document listed in the subpoena and not in control of those documents, hence the subpoena. In the case of Obi Odu against Duke, the Court of Appeal held, and I quote, "The person subpoenaed here is a principal party. The documents sought are very clearly and distinctly identified. These are all documents which are personal to the first respondent and are therefore under his personal control and custody," unquote. It is therefore the finding of this court that the documents the subpoena officer of the defendant applicant is to tender are listed and not vague. Hence, the subpoena summons does not in any way amount to an attempt to unjustly break into the camp of the defendant's official records. The defendant applicant makes the application of the defendant an issue before this honorable court. And the only way the claimant respondent can disprove the claim of the defendant respondent is to subpoena the officer who is in control of those documents to produce them. Yet again, the fact that the claimant respondent had earlier, through the reply to the statement of defense, give notice to produce does not vitiate the issuance of subpoena on the appropriate officer of the defendant applicant. At arbitral proceeding, as with all proceeding, counsel has general authority to decide in his discretion on how to conduct his case, and see the case of NNPC against Clipco Nigeria Limited. The defendant applicant stated in affidavit in support of the application that the documents ought to be produced are documents belonging to the Delta State government. The state government does not consent to anyone producing the said documents. It is instructive to state here that the defendant applicant did not give any reason. The state government did not consent to producing those documents. And there is nothing before this court to show the disapproval of the Delta State government for the production of the said documents. I'm not oblivion of the provision of Section 90 and Section 19 of the Evidence Act, as the circumstances mentioned there do not apply to this case. There is nothing before this court delineating that the documents ought to be produced are unpublished official records relating to affairs of state, as provided for in Section 90 of the Evidence Act. Neither is there anything before this court that public interest will suffer by the disclosure. Even if they are, such circumstances do not halt the subpoena witness from tendering the documents sought to be produced before this honorable court. In view of the foregoing facts I enumerated by initio, I have no hesitation to hold that this application lacks merit, and same is hereby dismissed. Our ruling is hereby entered accordingly. Yes. I cannot hear you. You have to unmute your...
Okay. We thank my Lord for a well-considered ruling, very detailed ruling. We are most grateful, my Lord. We are more grateful, my Lord.
Yes. I think we have other applications.
Yes, my Lord.
I think we have to take all the applications.
We have a motion on notice. Yes, my lord, we have a motion on notice. Well, I think there is interruption from my learned friend. I think he's okay now.
Yes, so Trupanwe, can you unmute? You have to unmute your. Yes.
Yes, my lord.
Yes.
My lord, we are much obliged by that ruling. And I will say this, that of course, we want to apply for a copy of the ruling so that we can react, we will react to it. But I appreciate the difficulty of access to the court at this time.
No problem.
I appreciate the difficulty of the access to the court at this time.
Yes. So let's take other applications that are pending.
Yes, my lord, there's
yes, Mr. Trupanwe.
My lord, there's one application or two applications pending. But as we said the last time, our application for amendment, we will have to withdraw that application for amendment because of their application to amend the statement of claim.
Okay.
And then ask for leave to make consequential amendments to that application.
Okay. So now we are going to take Mr. Appa's application for amendment.
Oh, please.
Yes, Mr. Abba.
Yes, my lord.
Your application is dated 20th April.
20th April, my lord.
And filed on the same date.
Filed on the same date, my lord.
Okay. Yes, go ahead, Mr. Abba.
My lord, the motion is brought pursuant to Order 3622 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 and under the inherent jurisdiction of this honorable court. My lord, the application is praying this honorable court for 3 reliefs, my lord. The prayers are endorsed on the face of the application, my lord.
Yes.
The first prayer, is another granting leave to the claimant applicant to amend his complaint in the manner underlined and set out in the proposed amended complaint and statement of facts herein attached and marked as A. Another to the claimant applicant to file additional statement of oath and additional document to be required as required in time amendment, my lord.
Yes.
So the application is supported by a 10-paragraph affidavit. 10-paragraph affidavit proposed to by Agawa Aibo.
Yes.
My lord, and next to the 2 exhibits. And next to the affidavit are Exhibit A, the bundle of document attached, Exhibit A.
Yes.
Exhibit A, my lord. My lord, we rely on the paragraphs of the affidavit and the exhibit annexed thereto. The exhibit is the proposed amendment, my lord. The proposed amendment and the document seeks to be additionally tendered, my lord. My lord,
yes.
in compliance with the rules of this honorable court, we have filed the written address. The written address is dated 20th April 2022, my lord. We seek to adopt the written address as an oral argument in support of this And we urge my Lord to grant the prayers and cause of this application in the interest of justice.
Yes.
We are most grateful, sir.
Yes, Mr. Torpanowe.
My Lord, just to say this, my
Yes.
learned friend is talking of filing for leave to file additional statement on oath. My Lord, what my learned friend has done is to attach the proposed claimant's written statement on oath. There's no additional statement on oath.
Hello, is proposed. Is proposed.
You said additional state.
You have to file the proposed witness deposition. You have to file the proposed witness deposition.
Yes, my Lord.
My Lord, it has to be headed at
my Lord, it is after the order is granted that we can now file the witness deposition. This is just an exhibit. It's our intention.
My Lord,
of what,
my Lord, the thing is this: your additional witness on oath, my Lord, your additional witness on oath is not a repeat of the witness deposition you have filed before. It is limited to the new issues that you are raising in your amendment.
Yes.
That's not what my learned friend is doing in this case. That's not what he's doing.
My Lord,
my Lord, if he wants to amend and bring the proper application to file an additional witness deposition in line with his amendment, we have no issues with that.
Yes. Okay. Yes, Mr. Abba.
My Lord, what we have done is we are amending the operating process.
Yes.
The complaint is to be amended. A statement of fact is equally going to be, we are paying for the amendment of the statement of facts.
Yes. That's not your application. You are asking for additional witness, not to amend your original witness deposition. That's not your application.
Mr. Otorpanowe, allow Mr. Abba, let him state his position. Let's hear him.
Yes, my Lord. My Lord, what we have done is to attach Exhibit A. The Exhibit A set out the portions of the complaint that we sought to amend. We have also attached the statement of facts, which reflect the portions of the statement that is to be amended.
Yes.
The proposed amendment, the law grants us this application. The proposed amendment captures what represents the case of the claimant as at the date of the amendment.
Yes.
So it does not inflict any injury whatsoever on the defendant, because after this amendment, I'm not going to adopt a witness statement or note that was earlier filed, because it's an entire process that has been amended. So we're filing a new statement of fact. We're filing a new statement of fact, tag amended statement of fact. So the witness statement that accompanies that new statement of fact is what is going to proceed to trial. It's not the one we filed in the past.
My Lord, with all due respect, if he wants to recall a witness, the witness can only come to adopt the additional statement on oath.
On oath, yes.
The additional statement on oath, additional deposition, that's the only thing the witness can do, because the witness has already adopted the witness deposition, which he cannot run away from now. He can only adopt the additional witness on oath. That's all he's entitled to do.
Yeah, my Lord, the witness.
Yes, Mr. Otorpanowe, I thought if you are opposed, you could have reply him and oppose the application.
My Lord, yes, I could have, but it was an oversight. It was an oversight. But my Lord, this is a court of law, and this is just, it's plain.
Sorry, my lord. Sorry, my lord. We have only called the witness in this case, and we don't even intend to recall that witness.
Yes.
The witness statement or note we have proposed to file, it does not even include the witness that had already been called. We are not even recalling. It's the witnesses that we have not called that are filing this new witness statement or note, and it makes the entire process.
Then you would not have called it additional. You will have called it, you will have asked for leave to amend or substitute your witness depositions.
In the
not
list
additional
of,
witness depositions.
in the list of witnesses, that we have also indicated that we are still subpoenaing witnesses. But Lord, this is just is neither here nor there, because it does not inflict any confusion or any injury on my learned friend. It's rather to make the entire process very tidy.
Yes.
It's tidy as it is.
So in the circumstance, my Lord, I urge my Lord to grant this application. There is no objection to this application, my Lord. We do not intend to recall any witness. And these witnesses before court, they have not even testified. So you have all your rights to cross-examine them anytime they come to.
So there are about seven witnesses now.
7 witnesses, my Lord.
Okay. Yes, Mr. Trofano, you have opened this, as you had earlier said, that he intends to apply to make consequential amendment.
Yes, my Lord. My Lord, in view of access issues to the court, we'll be asking for 21 days.
Okay.
We'll be asking for 21 days to file, because hopefully by that time, we'll be able to get to the court.
Yes. Because the situation is very, very...
It's terrible.
Precarious. Now it's terrible. Even me, I'm an IDP here, as you are seeing.
So serious,
I'm surprised my Lord is still in Yenagua when many looked for the fastest means to get up. A friend of mine had to go by truck, that's tipper, and by boat. Did the boat trip 3 times before she could get after Okogbe, other axis, and then be able to continue to Port Harcourt. It's terrible. And I imagine the environmental, that's the infrastructural damage that they will see after the flood.
Yes.
That's why I'm asking for 3 weeks so that the place will dry up. I will see how we can navigate to Yenagoa. That's the position.
Yes, Mustafa.
Yes.
We really must commend my Lord that at this difficult time, my Lord is still sitting, delivering justice. We are most grateful, my Lord. We are most grateful. And the Lord will continue to strengthen you, my Lord.
Okay.
My Lord.
Yes.
This is on the side now, my Lord. The new rules, the new practice direction.
Yes.
Okay.
Came after we had filed this application.
Yes.
And the new practice direction makes provision for referring to, in terms of referring to the document, we have covered that. Our process covered the reference to the document in our written statement or note and all the. But he still said that we should make reference to paragraphs.
Yes.
I don't know how.
Underline them.
Underline them. How do we, in the face of this amendment, can we incorporate that after the order is laid?
Yes, after the order.
For the purpose of the practice direction, if
Yes.
my law can also direct us to comply with the practice direction in
Yes,
filing
talking
3
about
copies.
marking of documents.
Yes, my lord.
Marking of documents and exhibits.
As copies, my lord.
Yes.
We've already marked them in the witness statement or note, in the complaint and statement of fact. They have been marked accordingly. But in terms of reference to paragraphs, that is just the only area that we have not done, my lord. I know it's equally very tedious and
prestigious. Yes, after the order, where you are filing. That is F. A defendant witness or statement must clearly indicate all the documents he intends to rely upon at the trial of the case, and the paragraphs or pages or parts of the document to be relied upon in the attached document must be consciously referred to and be appropriately marked as to be discernible in terms of facts being proved. That's the one you are talking about.
No,
that's
he's talking of both. Yes. He's talking of both
marking of the paragraphs
by both claimants and defendants.
Okay. Defendants. Okay. In terms of marking and referring of paragraphs, yes.
Paragraph.
Yes. If you are after the order, if you are filing, you have to do that.
As court pleases. We are most guided and grateful, my lord.
My lord, what of in respect of exhibits that have already been tendered?
Okay, yes, the one that already, yes, they have been tendered. That's another.
My lord, in all except one in the subpoena have been tendered.
Yes. Okay.
All except one.
All the documents listed. Okay.
Except one has been tendered. So is he going to refile those documents that have been tendered and underline them, refer to the portions in accordance with the practice direction?
The practice direction.
My lord, the document that have been tendered already form part of the process.
It forms part of the record of the courts. It forms part of the process. I mean, for now, right. Any other document he is going to file, it must be in accordance with the practice direction. But all other documents are admitted before the coming in force of the practice direction. I think there is no need.
It's all right, my lord. We need to get that clear.
Sorry, my lord. My network was bad. I didn't get.
I said all those documents which already are in custody of the court, that is tendered, admitted, and marked as exhibits. That is before the coming in force of the practice direction. Because there is no problem. There is no need for you to do that. But any other subsequent document which you are going to file or tender must conform with the provisions of the practice direction.
We are most guided, my lord. We are guided, my lord. We are most guided. Okay, talk.
Deliver better.
I have considered the nature of this application, the amendments contained in the subject written address, and I have equally perused and analyzed the annexures attached therein. And I have equally analyzed the provisions of Order 26, Rule 2 of the Rules of this Court. And in the absence of any opposition, I found the application meritorious and same is granted. I grant the prayers as contained on the face of the motion paper. I order the applicant to amend and file the amended process and serve same on the defendant. And taking into consideration the flood situation in Bayelsa State, making this court not accessible to litigants and their counsel from other jurisdiction, I rely on the provisions of Order 5 of the rules of this court. I order parties to file an exchange process within 21 days from today. And I also grant leave to the defendants to sequential amendments in line with the order made by this court.
As God pleases.
So give us a date.
November 16th.
21
days forth.
You have had 21 days just now.
Today is 25. November 16th. Before Kigali, after Kigali.
Say 21 days. He will serve us, then we'll have 21 days. That will be taking us to either late December or January as it is.
Today is 25.
I will find my process what the end of this week.
Give them 28 or 29.
28th November.
What time?
28th November. It's a Monday.
It's convenient, my lord.
I'm in High Court too, worry, my lord. 29th is convenient.
30th, any day that is convenient.
29th is convenient.
28, 29, 30th. Okay.
30th is convenient, my lord. 29th is not convenient.
Okay, 30th is convenient for me.
Okay.
Wednesday.
Oh. Sorry, my lord. Sorry, my lord. 30th is not convenient. Sorry, my
yes.
Lord. 30th is not convenient.
That is December then.
December.
Sorry, if we can come on the 5th, my lord. 5th.
It's convenient.
No, 5th, I'm at the High Court, Ugeli. 6th is okay for me. 6th, 7th, 8th
is convenient
okay for me.
6th is convenient, my lord. 6th is convenient.
6th is convenient to the court.
It's a Tuesday.
With the consent of both parties, matter adjourned to 6th day of December 2022 for continuation of trial.
My lord, I don't know, sir. We are much grateful,
Yes.
my lord. I don't know, my lord, when I can see about getting a copy of the ruling, my lord.
Now. You can get it now. Yes, if you can.
Okay, a printed copy.
They can scan it to your email.
And send to the email.
Yes.
Okay.
Mr. Appa and Mr. Tropano, if you can supply your email to the registry, they will scan it to you now.
We are much obliged, my lord. We are much obliged. Thank you, my lord.
We are grateful, sir.
Okay.
Yes.